Pinky, we are joined here by Senator Miriam Santiago for her first day of attending the trial. But then again, so much has already happened as we predicted earlier. Ma'am, good afternoon.
Hi, good afternoon. I'm very happy to be back.
Good afternoon, and your impressions of your first day attending the trial.
Nakakainip. At nagiinom na lang kami ng tsa para hindi kami matulog.
But ma'am, I think there was some...
Masyadong matagal.
There was some exchange at the end. Pero ano po ba talaga, maybe you can explain to us, what really happened, why the trial for today was adjourned?
Ganito kasi iyon. Ang nakalagay sa ating rules of court ay, una, sa complaint mo, ilista mo na lahat ng krimen na sinasampa mo laban sa akusado. Ngayong pag ang iyong ebidensya ay hindi nakapailalim sa maski anong krimen doon na nilista mo, hindi ka na pwede maglabas ng ebidensya na iyon. Bakit? Dahil hindi mo binigyan ng pagkakataon ng akusado na ihanda niya ang pagtatanggol niya sa sarili sa krimen na iyon. Ngayon, ang nakalagay lang sa isang article of impeachment na pinag-uusapan natin ay na ang krimen ni Chief Justice ay hindi siya nag-file ng kanyang SAL-N. Ngayon, pinakita na nitong bista na ito na nag-file naman pala siya. Kaya sabi ng depensa, di tapos na yung paksa na yon. Pero sabi ng prosecution, hindi. Tingnan muna natin ang income tax returns ng kanyang mga pamilya, anak niya at in-laws niya. Kaya sabi ngayon ng depensa, bakit pa? Tapos na yung sinasabi niyong hindi siya nag-file ng SAL niya, nagbigay na kami preba na nag-file nga siya. Ay sabi nila, pero kalakip yon. Kaya ang question ngayon ay, iyan bang pag-file ng income tax return ay kalakip na o kasama na doon sa pagbibintag sa kanya na mayroon siyang krimen dahil hindi siya nag-file ng SAL-N niya. Kaya parang malayo, no? Kung sagutin mo lang. Pero ang akin iniisip ay, baka pag hindi natin pinayagan na ipakita itong SAL-N na ito, baka sabihin na naman ng publiko na may tinatago. Ay, itong Senado na ito, pampolitika lang pala dahil meron palang ebidensya na tax returns ayaw nilang pakita sa publiko. Kaya kako dapat, ang ating rule ay hanggat sa maaari, kung ebidensya, tanggapin na lang natin, basta subukan lang natin na hindi paligoy-ligoy ang prosecution dahil hahaba ang bista. Kaya dapat bago tawagin ang bawat testigo, dapat sabihin muna, ano ang pakay mo, anong inaasahan mong mapuntuhan mo dito sa testigo na ito, saka tanungin mo na kaagad ng tanong niya. Kaya bukas na namin sa alas 12, i-resolbar o hatulan yung pagtatanong na iyon. Pwede bang tanggapin namin ang Commissioner of Internal Revenue na ipapakita niya ang mga tax returns ng mga anak at mga in-laws ng Chief Justice. Yung
hinihingi po nila na ninyo na memorandum to be submitted at 10 a.m., that was also a reason why you decided to adjourn early because the prosecution was not able to submit.
Oo. Kasi dapat normally yan kung hindi magkasundo ang dalawang abogado, sa halip na magkatunggali sila, magdebate sila doon na it takes a lot of time, normally ang judge magsabi na lang, isulat nyo na lang at ibigay nyo sa akin at basahin ko pareho. Kaya kanina, nabigyan nga silang pagkakataon magsalita bawat panig, pero nagbigay na ng memorandum ang defense. Kaya sabi ng prosecution, ay sila lang may written memorandum, kami rin. Kaya binigyan sila hanggang alas 10 bukas. Dapat dyan sana, ang prosecution, ready na with their memorandum. Dahil alam naman nila na when there is a contentious issue, during and in the course of the trial, the normal habit is you ask the parties to submit memoranda. Kaya dapat handa na sila. Kaya medyo mabagsik ako kanina sa prosecution dahil sa tingin ko, hindi nila ina-anticipate, hindi nila iniisip kung ano bang magiging kasunod. Kung batid na abogado yan, alam na niya yan, may trial brief na siya, in-outline na niya kung anong gagawin niya.
Senator Santiago, one of the issues is the liberality or the non-liberality of the Senate impeachment court. Now, when Senate President Enrile started asking the prosecution, so how do you want me to be liberal? They were kind of, let's say, dumbfounded.
Not sure.
What's your comment on that,
That is
Madam
the
Senator?
problem. You do not make this kind of general requests or appeals to your judge. You say it in a specific term. Can we please, for example, introduce hearsay evidence that is not allowed under the rules of court, but this is a different court, this is an impeachment court, it is sui generis, it is in a class by itself. So can you please allow us to do that? Dapat ganon. Kaya mag-answer na lang kaming bilang senator judges, yes or no. Pero it was a general appeal. Please be liberal. Liberal in what way? Because you know, there are so many shades of liberal, but we are guided by the provision in the rules of court that the rules of court shall be liberally construed. Meaning to say, if it is in pursuit of the truth and does not substantially prejudice a constitutional right of the person involved, then we should allow it. That is the meaning of liberal construction.
Ma'am, are there any complaints on the part of the senators? Kasi parang sinasabi ng prosecution, masyado silang pinaghihigpitan, and so it led to this, well, a little, medyo nagkatampuhan, I would say, no?
Right.
Judging by the way Senator Enrile was talking earlier. But
Right.
on the part of the senators, are there any complaints on the way the Senate President is running the trial?
No, we are all unanimous behind him. If there is any doubt, the doubt will be resolved in favor of the Senate President. I think that is the better rule. And also, we hold regular caucuses in executive session, and we discuss with equal rights what the pending issues are. So I don't think that you can fault the presiding officer. I think it is more a case of the prosecution is not at its best yet. So I hope that it reaches that point very soon, preferably tomorrow.
Adele.
Senator Miriam, I think one of the more, let's say, revolutionary things that you've stated today is the possibility that instead of a conviction, that the Chief Justice may be given a censure or a reprimand. Would you please expound on this?
Kasi napansin ko, hindi naintindihan iyan ng publiko, pero nasa ating saligang batas iyan. Nakalagay doon na if convicted, sabi niya, the person impeached, either the President or the Chief Justice, or any other of the eligible officers under the Constitution, shall be meted a penalty of no further than removal from office and disqualification from public office. That phrase, no further than, ibig niyang sabihin, you can impose a penalty less than removal from office. So you can, for example, impose a penalty of merely censure or reprimand. That's the logic of that constitutional provision.
Is this something that the Senate will have to agree upon? I am not sure if anyone disagrees with that kind of interpretation or position that you have taken, but is this something that you will have to discuss, let's say, in caucus?
Well, first we have to discuss what is the standard of proof. That has not been discussed here. In fact, it should be part of the rules of the Senate. Kasi you determine more or less the fate of the accused depending on what is your standard of proof. There are several standards of proof. The most lenient standard, malamang sa maabsuelto ang akusado, ay if you apply the standard of proof in civil cases, which is merely preponderance of evidence. Kaya dalawang ebidensya, umangat lang ng konti ang sa defendant or sa respondent, panalo na siya. That's preponderance of evidence sa civil cases. Sa criminal case naman, napakataas ng standard. It is proof beyond reasonable doubt. Kaya kung may duda, acquitted na ang akusado kaagad-agad dahil ang taas eh. You just prove one half. You just prove in court that there is one half of a reasonable doubt. You are bound to acquit. That is the problem with that level of proof. In between, meron pa iba. Meron pang clear and convincing evidence, substantial evidence, and so on and so forth. So, gusto ko sana mapagkasunduan na namin sa Senado at ng mga prosecution and defense kung ano ang standard of proof. Ay natural ang defense gusto nila proof beyond reasonable doubt dahil napakahirap niyan. Malamang sa maabsuelto ang client nila. Sa kabila naman, ang gusto yata nila was, if I remember correctly, was substantial evidence, which is very, very low. So, if you have so much as just one or two pieces of evidence, pwede na. So, we have to resolve first of all, what is our standard of proof? And then our rulings as Senate Court will follow from the standard of proof that we are applying.
I heard you earlier in your press conference this morning that your position is that it should be overwhelming preponderance of evidence. So, what does that mean for us non-lawyers?
Ang ebidensya, kung balansyado sila ganito. Ngayon, preponderance of evidence is umangat lang ang isang side, panalo na siya. Kung sino nakaangat sa kanila, konti lang. That is preponderance of evidence. Overwhelming preponderance of evidence is like this, na ang dami-dami niyang ebidensya, kaya overwhelming, mas marami siyang ebidensya ng sa dito, hindi lang konti ng ganito, kundi ganyan. Kaya mahirap siyang makonvict.
So tomorrow, ma'am, we expect that the prosecution is supposed to submit at 10 a.m.
Yes.
Can we expect the Senate already to rule
Oh,
on,
yes.
on these two
We have a
memoranda?
caucus scheduled for 12 o'clock. So we'll wait until 10. We have the 2 pieces of memoranda before us, then we'll choose which side is correct.
And again, just to refresh, this memoranda will spell out or they will try to argue which one is the correct interpretation, whether you
That's
can
right.
include failure to disclose other properties
That's
and
right.
accumulation of alleged
Yung
ill-gotten
aking
wealth.
sinasabi sa kanila, nung Estrada impeachment, napaka-stricto ko. Gusto ko sundin talaga ang rules of court. Eh, hindi pwede yan sa rules of court. Kung ano lang yung linagay mo, yun lang ang pwede mong bigyan ng ebidensya. Kung bigyan mo man ng panibagong ebidensya na hindi nakalakip doon sa mga krimen sa complaint mo, amendahin mo muna, baguhin mo muna ang complaint mo. So I said, we can accept the evidence, we can open the second envelope provided that the complaint or the article of impeachment is first amended pursuant to the rules of court. Yun ang paliwanag ko. Pero the public did not care about my technical explanation. Parang ang feeling nila, that is too technical. So among other people who were demonized, was me because I voted against second envelope. Eventually, with the passage of time, I was vindicated because after all, the second envelope was opened and there was nothing incriminating against the accused. So I learned my lesson. As Oliver Wendell Holmes said, the life of the law has not been logic, it has been experience. Yun ang aking experience, yun ang aking karanasan na gusto pala ng publiko, basta may ebidensya at may pag-uusap kung ito ba'y tatanggapin natin o hindi natin payagan na tatanggapin. Gusto pala ng publiko, tanggapin na lang para malaman nila. That is why I was saying this afternoon that as much as possible in the admission of evidence, our Senate court should be liberal. Kung may ebidensya, tanggapin mo na lang. Basta siguraduhin mo lang na huwag masyadong matagal ang pagtatanong sa testigong yon.
So ma'am, ang ibig ba sabihin nito, after the two sides have submitted their memoranda and the senator judges have deliberated on it, there is a possibility that the prosecution will be allowed to amend this particular article of impeachment to include yung two other grounds.
Hindi naman lang kailangan yan eh. That is the provision under the rules of court. Pero as I argued it today, my position is, we can just simply rule, hindi na kailangan amendahin pang original complaint. It shall just be deemed to be admitted there, to be included there, and immediately the Commissioner of Internal Revenue can take the witness stand.
Yeah, Linda, I think one of the advantages of Senator Santiago is she was actually a trial judge.
Yeah.
And I noticed that your let's say a motion for there to be a witness list that was born out of your experience.
That's right.
Are you going to have other interventions, like for example requiring judicial affidavits or admissions? Are these things you're going to propose?
These are discovery procedures, as so-called, no? These are normally steps that are taken during pre-trial. Para hindi mag-fishing for evidence, sa ating rules of court, kailangan mag-avail ka ng discovery procedure. Ibig sabihin, hindi ka pa sigurado kung relevant itong testigo na ito, itong dokumento na ito, pero naghingi ka ng paalam sa korte kung pwedeng kumuha ka na ng affidavit nitong taong ito. That is called a discovery procedure. And you take his testimony just before the clerk of court, not before the entire court. Things like those. Now it would technically be too late because we're already in the middle of trial. But I will make all of those suggestions at a proper time, even during trial, because as I said, the rule should be liberal construction of the admission of evidence.
Ma'am, in your estimate, how long do you think will the trial take?
Hindi niya alam kasi kanina tinatanong natin, sabi ng prosecution, 7 ang aming testigo ngayong hapon.
Yes.
Only, oo.
Oo. Pwede ko sanang sabihin, hindi pala pwede pa si Internal Revenue Commissioner ngayon, baka bukas pa. Ay di, tawagin mo na lang yung isang testigo mo. Pero kamukha ng lahat, gusto ko na ring umuwi. Kaya, baka hindi na nila ako kibuin bukas. Kaya nahimik na lang ako. Sabi niya, 7 ngayong araw. Hindi, sa kabuuan. Ilan kaya? Pwede bang sabi niyang 3 days from now, I will submit. And then the defense, alam na niya kung ilan.
Yes.
Kaya, i-estimate na lang natin kung bawat testigo, isang session na lang kamo. Dahil may direct examination, may cross-examination, may redirect, may recross. Sabihin mo na lang isang session bawat isa, di ma-estimate natin kung ilang session itong ating vista.
And nabanggit po ninyo, ma'am, that you want a list of the witnesses, their names, and the substance or the
That's right.
content of their testimony.
So,
Does this mean that there should be no surprise witnesses.
There should be none unless, of course, there's a very unusual circumstance that justifies it, because the very essence of due process is the right to be heard. Meaning to say, binigyan ka ng notisya muna kung anong kasalanan mo, tapos may panahon ka na gumawa ka ng pagtatanggol sa sarili mo so you can build your defense. Ngayon, kung mystery or surprise witness, di walang due process dahil hindi ka sinabihan, biglaan lang. Ano ngayon ang itatanong mo sa cross-examination? Kaya, pwede kang mag-so-called surprise witness, but let us say, after you have given notice 3 days in advance, para hindi naman unfair doon sa katunggali mo.
So, ibig sabihin, pag nag-submit sila by Thursday ng list of witnesses, pwede pa silang magdagdag
That's right.
at a later date.
It will not bind them,
Okay.
of course.
I'd like to clarify that, Senator Santiago. I think one of the things that Senator Enrile said, Linda, was parang effectively, I've given you guys enough time. Dapat pagdating nyo dito, handa na kayo sa lahat ng witnesses nyo. So Madam Senator, I guess what I want to clarify is when you talk about a witness list, it is not just for this article. You're talking about a witness list
For the
all,
whole trial.
The whole trial, and including what will be the order of the articles.
If possible, yes. Kasi, meron dyan sasabi, alam ko nang sasabihin yan eh. It depends. It depends on what is the evidence produced by the other party. So it might become necessary to introduce more witnesses to rebut what he said, no? Kaya, nag-iiling pa lang kanina, pinagpagalitan ko na, pinagsasabihan ko na, oh no, don't give me that. Dahil, more or less, alam mo na yan, wala yung surprises eh. Kaya nga kako, dapat bawat panig yan, may trial brief yan na parang outline yan kung sinong testigo niya, anong direct niya, anong magiging cross niya, para mapigilan mo yung question on cross-examination.
Just a final question for Senator Santiago before, unless studio has, Ma'am, you were absent last week on account of your health. Do you think at this point you can already sustain attending the hearings?
I hope so. I intend to stay because I have to leave by March, take my oath in the ICC, and then I will come back. So marami na akong absences. I will force myself to attend even if they have to take me out horizontally.
On that note, thank you very much, Senator Miriam Santiago. Always a pleasure to talk to you. Salamat, ma'am. And then we toss you over to the ongoing prosecution panel briefing.
Nailabas din po yun.